Is it possible for an American from Iowa to leave his property and some financial support on his last will, even when the person is from a different country, like in the Philippines? Okay, so I'm not licensed in Iowa. However, I'm going to address this comment in accordance with Florida law because it is interesting. I do get this from time to time. Where people will ask me if they're from another country, can they inherit something from one of my clients? Or I'll have clients come in and they want to leave either real property or some type of asset to someone in another country, and they want to know if they can do that through their Florida documents, whether it's a Florida last will and testament or a Florida will. So here's how it works, at least in Florida, and you'd have to double check this with an Iowa attorney if it's the same there. There's no restriction on a citizen in the U.S., as far as I know, leaving property, whether it's real estate or assets like a bank account or a money market or an investment account, to someone who lives in a different state from them, or even to someone who lives in a different country than them. However, there's special things to consider when you're doing this. One, depending on what all is being left to a person who is not a citizen of the U.S., let's say that they're being left most of what's in this person's estate, maybe their home and most of their assets. Well, if the person who's out of the country isn't either married to the person who's leaving them these items or related to them through blood, then at least in Florida, they can't serve as the personal representative, also known as the executor in most states. That is going to be the person who has the responsibility of making sure these assets go through the court process called probate so that they can be passed down to the individual who's inheriting them. Oftentimes I find in my practice that when you have someone who's inheriting the bulk of what a person owns, but they're not qualified to serve as the personal representative, it can sometimes be a little challenging because you have to find someone else who can actually serve as the personal representative. And in probate proceedings, especially if there's several beneficiaries, people are inheriting through a will, or if there's many people who sort of have an opinion regarding the assets, that can make for sometimes a complicated and expensive probate process. Also, again, I don't know the law in Iowa, so I'm not certain what their rules are on inheritance tax, or sometimes people call it death tax. In Florida, there is no state inheritance tax. But there is federal inheritance tax that applies when an individual is either gifting during their lifetime or through their will or their trust an amount greater than $13.99 million. So that's the current exemption amount under federal law. But what's interesting when we're talking about giving something to someone in another country, like the Philippines, there could be special tax consequences that need to be considered for the person who lives in the Philippines. This could be related to owning property in Florida, especially if it's income earning property and how that gets taxed if the person isn't a U.S. citizen. Also, just as far as inheriting the property is concerned, maybe they sell it, maybe they just inherit accounts. Just because there may not be taxation in the U.S., it doesn't mean that there isn't the possibility of taxation in the Philippines. In fact, there very easily could be. And if you're in a state that does have a state tax for the amount that you're inheriting, you could be facing double taxation. So this is why it's often really important, if you're including someone from another country in your estate planning documents, especially something like a will where they're going to have to inherit through probate, and probate costs money, that you also consult with an attorney, tax professional who knows, familiar with international tax, or an attorney who does estate planning or taxation in the country where the person lives, because it's not enough to just know what would happen in the U.S. or the specific state that the assets are going through the probate, you really need to know the whole picture and how this is going to play out for the individual, not only in the U.S., but also in the country they live in, especially if the person isn't a resident of the U.S. or planning on becoming a U.S. citizen at some point. There's definitely special considerations there as well. Okay, so I know this probably wasn't a lot of help with regard to Iowa specifically. You would have to double check as far as the similarities between Iowa and Florida, but it'd be really smart that if someone's considering doing this, not only should you really consult with a estate planning attorney in Iowa, but you should also talk to someone who has international law experience or an attorney in the Philippines, because this should be a decision as far as what you're doing, what you're getting, what the consequences are going to be from a tax perspective. All of these things should be known in advance of the estate planning. All right, I hope this helps. If you have any other questions regarding who you can list as a beneficiary in your documents, or hey, maybe is it better to do a will or a trust, because this also kind of comes up under this scenario too, or anything like that, and you're in Florida, don't hesitate to contact us. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.